appeal, the Queen on the application of Coll and the Secretary of State for Justice.
Yes, Elizabeth. My lady, my lords, I appear in this matter with Mr. Steele for the appellant, Ms. Coll, and my learned friends, Mr. Chamberlain QC, Mr. Sanders QC on his first outing with that title, and Ms. Apps appear for the respondent. The court also has a short written submission and a witness statement from the Howard League for Penal Reform, which were produced yesterday, permission having been given for their intervention last week. Under the Offender Management Act 2007, it's the function of the Secretary of State to ensure that sufficient provision is made throughout England and Wales for the supervision and rehabilitation of persons who've been convicted of offences. That function includes the provision of accommodation in what are known as approved premises, or APs. These are residences where relatively high-risk prisoners who are released on licence may be required to live for a period of time as a condition of their release on licence, under a strict and supportive regime of supervision. The aim is both to protect the public and to assist in their reintegration into society. APs also accommodate some individuals who are on bail, but in these proceedings we are concerned with their function in relation to prisoners who are released on licence and who are required to live in them as a condition of their release. Now, my lady, my lords, the problem that arises in this case can be seen from two maps which are in the bundle at MS 211 to 212, but not very well reproduced, so which we've provided in larger hard copies. And we have in a rather retrograde fashion, got the women's APs on here in pink and the men's APs in blue. And the issue that arises in this case can be seen very clearly from these maps. The position is that there are 94 APs for men and only 6 for women. The APs for men are spread throughout England and Wales, but the women's APs have a very limited distribution. In particular, as the court can see from the map, there is no women's AP in London, where Ms. Coll, her family live, her children and grandchildren. There is no women's AP in the whole of Wales. There is no women's AP southwest of Reading, if you look at the map. None at all in East Anglia, and none north of Leeds. That's just an indication of the extent to which there is simply no provision made for women in very large areas of the country. As a result, it's inevitable that many women who are required to reside in APs are placed many miles away from their homes, their families, and their communities, with consequential detrimental effects on their rehabilitation. This is not the result of any coherent policy on the part of the Secretary of State. The distribution of APs has simply evolved in a piecemeal fashion historically. For example, because there are far fewer women in the criminal justice system, and the pressure on space in the men's facilities has been greater, on a number of occasions, women's facilities have been redesignated for men. So in fact, the number of facilities for women, available for women has tended to decrease over time. There was until relatively recently a facility in London at King's Cross. It had various deficiencies, not least that it was in a notorious red light district where some women felt unsafe, but it has now been re-rolled in the jargon as a male AP. There also used to be some mixed facilities, and they have now also either been closed or re-rolled as male facilities.
Nobody's arguing for them.
No, nobody's arguing for mixed facilities. It's generally agreed that given the particular vulnerabilities and life experiences of women, they are better off in single-sex facilities. That's not in dispute in these proceedings. So the number of facilities for women and their geographical distribution has decreased over time without there being any coherent policy behind that. Now, in this context, the questions which this court is asked to decide are as follows. First, whether the way in which the Secretary of State has provided APs constitutes discrimination against women, whether direct or indirect. Secondly, if it does, whether the Secretary of State has shown that the provision that she has made is a proportionate means of meeting a legitimate aim and therefore justified. And finally, if we're right, and the provision has been shown to be unlawful and discriminatory, whether the court should grant declaratory relief. As the court will know...
What's the declaration you're seeking?
Well, my lord, the precise wording of it is in our pleadings. Can I return to that at the end? Because it comes...
I'd quite like to know at the beginning what the declaration is.
Yes, I understand that, my lord. If you look in the
That's
court...
assuming the purposes of this
Yes.
proceeding is relief.
Well, my lord, to put it in a nutshell, the declaration that we're seeking is that the provision made for APs under the Offender Management Act discriminates unlawfully against women and has not been shown to be justified. Something along those lines. That would be the general terms of it.
So it has no particulars.
It doesn't, my lord, no.
I mean, for example, are we to consider whether there should be one in Taunton or Bath or... I mean, they're quite serious problems, these, aren't they, when you've got such a disparate difference between the numbers of people, of men on the one hand and women
Absolutely.
on the other.
If
If one was the Secretary of State, it's quite a tricky problem to resolve, even with the best will of the world and with the very best legal advice and doing everything tickety-boo in accordance with the book.
Yes.
Still, there's a very, very difficult problem to face.
Your Lordship's absolutely right. And the point that we have stressed throughout is that we are not saying that the requirement here is that there should be exactly the same number of APs for women as for men, or that they should be in all the same places.
Yeah.
What we say is this is a situation in which the needs of women for these facilities are different from the needs of men, and it's right that they should be single-sex facilities, but where the provision for women is less favourable, it must be shown to be proportionate. And my submission is going to be that this case turns on the question of proportionality. And what your Lordship's just put to me is this is a difficult problem which involves the Secretary of State in making difficult choices. The difficulty for the Secretary of State in this case is that there has been no attempt, and I don't put it any lower than that, there has been no attempt by the Secretary of State whatsoever at any stage to grapple with the problem or to work out how the disadvantages to women could be mitigated. And that's why we say the current provision is unlawful.
On your side, there's no positive suggestion as to what she might do by way of relief, is there? I mean, one reads the recent paper we got yesterday, and that's short of any such particulars, really.
Well, my Lord,
I mean, it has lots of very, very powerful points about how appalling the whole idea of having women in prison is at all, and all that, which is all very, compelling.
Yes.
But it doesn't really grapple, certainly not with the nuts and bolts of what we're now considering.
Well, the point is this, that there's a range of different ways that this problem could be tackled.
But one wonders why we haven't got any kind of sort of structure, have we, as to what it is the Secretary of State should be doing. It's easy to say she's hopeless, hasn't done anything.
But that's the problem. That's the problem, my Lord.
Right, I follow that, but anyway, the position is that on your side, no positive suggestions have been made, have they?
Well, my Lord,
except we need more.
No, my Lord, what we've said on our side is that at the very minimum, the Secretary of State needs to do a proper review to identify the extent of the disadvantage and to identify options for mitigating it and work out the costs and benefits of options. And at that point, the Secretary of State would be in a position to devise a proportionate policy. The problem in this case is that the Secretary of State's been told repeatedly that this is a serious problem and has chosen to do absolutely nothing about it. And that's what we say is unlawful. And so your lordship rightly says, well, where's the structure? Where is the way of addressing the problem? And we respectfully agree. And we say that's precisely what the problem is. Now, coming back to the decisions of the courts below, as this court will be aware, both the Administrative Court and the Court of Appeal found against Ms. Coll on the issues that I've identified. And the reasoning of each court is different from the other. The Administrative Court found that there was no discrimination because Ms. Coll was in a different situation from a man and couldn't compare her situation to a man. The Court of Appeal said that that reasoning was wrong, but found that she hadn't been less favourably treated, that there was no indirect discrimination, and that in any event the treatment was justified. We say, with respect, that the analyses of both of the courts below are wrong in law, and we also note that the stance that is now being taken by the Secretary of State on this appeal is significantly different from the analysis applied by either of the courts below. We say that the way the Secretary of State is now putting her case on this appeal is also wrong in law. I should note, however, that the new formulation of the Secretary of State's case was not made known to us until after we had submitted our own printed case. And as a result, this court has rather less assistance from me than I would have wanted to have given as to our response to it in writing, because we were not aware of their reliance on the Pat Mulneys line of cases until we received their written case. So I will be dealing with that today.
If you will assist us this morning.
I will. Now, this is how I intend to proceed. First, I want to identify the key facts, and in particular, the nature of the detriment that's being suffered by women, the concerns that have been raised over a number of years and drawn to the Secretary of State's attention, and the failure of the Secretary of State to take any action at all to investigate the problem or to devise any solution to it. Second, I want to look at the legal framework under the Equality Act and the relevant case law. And finally, I want to make my submissions as to why it is that we say that the current provision of APs is unlawful. There are some points that I would like to emphasize at the outset. The first is this: we maintain the complaint of indirect discrimination as a fallback position, and I'm not abandoning it. But my primary submission is that the correct legal analysis in this case is that this is a case of direct sex discrimination. It's our submission that women are being less favourably treated than men in their access to APs because of their sex. Ms. Coll specifically has been denied the opportunity of accommodation in an AP in London, where her children and grandchildren live, because she's a woman. If she was a man, in identical circumstances, she would have had that opportunity. The discrimination she has suffered is, we say, the inevitable result of the provision for APs that's been made by the Secretary of State, and in particular, the fact that there are several APs in London, as the court can see, and no for men, but no APs for women in London. What has now happened to Ms. Coll, we say, is simply one instance of the sex discrimination that will inevitably arise from the way in which the Secretary of State has provided APs throughout England and Wales.
Do we have any information
Yes.
about the spread of homes of the female offender population?
My lady, we don't. Because, as your ladyship will know, this is a claim brought on legal aid by one individual. And we're simply not in a position to have gathered that material. It's within the knowledge of the respondent. And one of the themes of this case is the failure by the respondent to collect any of the data that you would have expected in order for the respondent to mount a justification defence. Now, the second point I want to make, and this is very important, is that this is a very rare case under the Equality Act, because this is a case in which direct sex discrimination will be lawful if it's shown by the respondent to be justified. And this is really the legal importance of this case, because the scheme of the Act is to permit the provision of gender-segregated services, and further, to permit the provision of gender-segregated services that are provided differently where the need for them from men and women is different, but only where the limited provision is a proportionate means of meeting a legitimate aim. In other words, Parliament has specifically catered for what Lord Clark rightly puts to me as the difficult situation in this case. And it's done so not by taking this type of treatment outside the scope of the definition of direct discrimination, but rather by keeping it within the Act, but introducing a rare statutory defence of justification on the basis of the application of the principle of proportionality. The burden of proof was on the respondent in this case to satisfy that test, and we say that the respondent has failed to do so because she has done nothing to investigate the extent of the detriment being suffered by women, to address the costs and benefits of the various alternatives that could be put forward to mitigate the disadvantage, either before this case was brought, even after it was brought, and even after a declaration was made by the Administrative Court in these proceedings as long ago as December 2013, finding that the Secretary of State was in breach of the public sector equality duty. Since that declaration was made, nothing has been done. Now, the third point follows from the first two. We submit it is very important to keep separate in this case two different things. First, the factors that are relevant to the question whether there is sex discrimination. And second, the factors that are relevant to the assessment of whether the discrimination has been shown to be justified. Putting the matter very shortly, we say that it's clear that the provision the Secretary of State has made for APs for women is less favourable than that which she's made for men. And you can see it graphically illustrated on the map. That is clearly a less favourable provision for women. It's inevitable that that distribution of facilities is going to result in women being less favourably treated. You can't escape it. There's a men's facility in every town where there's a women's facility, and then there's an additional 88 men's facilities scattered in many places. The point that there are far fewer women than men in the system, so that it's more difficult to provide for a proper geographical distribution of facilities for women, goes to the question of justification. It goes to the question of proportionality. It doesn't go to the prior question whether there is prima facie direct sex discrimination in this case. Now, the logic of the respondent's position, saying that there's no prima facie discrimination, would be that there would be no discrimination in this case on the basis of the distribution of APs on this map, even if 50% of the prisoners in the system were women. You can test the respondent's argument in that way. If it was a 50-50 split of men and women, and you had this number of facilities for women and this number for men, on the respondent's case, there would be no sex discrimination. Now, that's one way we say you can see that what they say is wrong. Another way is this. On their case, there would also be no sex discrimination with the current distribution of women and men, 5% women and 95% men, the same number of men's facilities, and just one woman's facility at Land's End. On their case, that would not even raise a prima facie case of sex discrimination. Now, in my submission, what those two examples tell you is that there is clearly sex discrimination here. The real question on which this case ought to focus is whether it's been shown to be proportionate or not. Can I now turn first to the statutory function that the Secretary of State is exercising, and that is in Volume 1 of the Authorities Bundle at tab 3. And for those following on the screens, it's MS page 1818. And we start at section 2 of the Offender Management Act 2007, page 1820, where this is the function that the Secretary of State is performing. It's the function of the Secretary of State to ensure that sufficient provision is made throughout England and Wales for the probation purposes. And the meaning of the probation purposes, if you go back to 1818, is set out in section 1. And at 1C, you can see that the probation purposes means the purposes of providing for the supervision and rehabilitation of persons charged with or convicted of offences. And then over the page at 1819, the purpose set out in subsection 1C includes in particular, and then at C, supervising persons released from prison on licence, and at D, providing accommodation in approved premises. So what we get from a combination of section 2 and section 1 is that it's a function of the Secretary of State to make sufficient provision for approved premises for the purposes of the supervision and the rehabilitation of persons convicted of offences.
Are there analogous
Yes.
in relation to prisons? The reason I inquire is this: all the very forceful points
Yes.
made in your submissions and in the witness statement attached
Yes.
to the intervener submissions apply similarly to the entire distribution of women's prisons. Your clients are both, I think, in Askham Grange.
Well, in fact, one of my former clients didn't pursue an appeal. The other has now been released.
But she was in
She
Askham
was,
Grange.
yes.
Now, that is hundreds of miles
Yes.
away from her home.
Yes.
If she had been a male lifer,
Yes.
you would no doubt be able to show that she'd have been, in all probability, in a prison establishment much closer to home. So the implications are very considerable. It's slightly curious in the sense that she's limited her complaint to the 3 months potentially in an AP at the end of some years of imprisonment, and not made any comparable complaint in relation to the imprisonment hundreds of miles away during those many years. I'm just intrigued as to whether there's a particular reason behind that.
Well, my lord, I can't really comment. That's the complaint that was made and the claim that was brought. But in general, my lord, the fact that there may be systemic problems within the single-sex provision of services which are causing serious systemic disadvantage to women is not a matter that tells against this case.
No, not at all. But
because
we're looking at
yes.
in terms of the way in which women are treated through the criminal justice system.
Yes.
We're looking
at a small aspect.
Very small fraction.
We are, my lord. We're looking at one specific aspect of women's treatment in the criminal justice system. Now, just coming back to the statute, we don't need to look at it in detail, but just for the court's note, you can see at section 3 that there are various ways that the Secretary of State can make the provision, either through entering into arrangements with a third party or by providing the arrangements herself. And then if we come to section 13, this is at 1828, you see the heading approved premises. And here is the power for the Secretary of State to approve premises in which accommodation is provided, and at B, for or in connection with the supervision or rehabilitation of persons convicted of offences. And the definition of approved premises is premises that have been approved under that subsection. There's a regulation making power and the power to make payments in relation to their operation, construction, enlarging or improvement. So you can see that the Secretary of State has broad powers to ensure the provision of approved premises. And the nature and function of the approved premises themselves is summarised by the Court of Appeal. If we just take up the Court of Appeal's judgment, which is in the core bundle, it's page MS 102. And the court can see in the opening paragraphs of the judgment of Lord Justice Elias that he describes the regime in an AP. And I just draw the court's attention to paragraph 2, that we are talking here about a strict and disciplined regime imposing curfew hours and extensive security measures, purposeful activities and so forth. And quoting from Mr. Justice Cranston, the purpose of approved premises is not the provision of residential accommodation for its own sake, but residence is an integral feature of the enhanced supervision and risk management offered. And that's very important for a number of reasons. Firstly, because that explains why, for a number of prisoners, their choice is either to remain in custody or to be released to approved premises.
I mean, there was some suggestion that the average period spent in one of these places is 80 days.
Yes.
That's across the whole board, is it, including...
Some people will stay for significantly longer.
You could be there for years, could you?
I would have thought years is relatively unlikely.
You come up to the period when you would ordinarily be released,
yes,
but you're not regarded as safe enough
yes,
to go in.
You could be there for a significant period of time. But the point I want to make is that the disadvantage, and with great respect to Lord Justice Elias, I'm going to show the court where he does it. I think he, with respect, doesn't fully appreciate the extent and nature of the disadvantage. It's not simply while you're in approved premises, you're somewhat constrained. First of all, because of the curfew arrangements, and people are often subject to arrangements where they have to sign in regularly throughout the day, you simply cannot travel to see your children if your children are a long round trip away. So you're talking about women being very significantly removed from the ability to reintegrate their relationship with their children and families and their communities. But the problems persist after the end of the residence because those who reside in the approved premises will be looking for jobs and being allocated accommodation when they leave. And what has happened to Ms. Coll, and this is not untypical, is that she was unable to view properties in London because she couldn't get a travel warrant to travel from Bedford. As a result, she has now left approved premises and is being accommodated in Milton Keynes. And you can't turn the accommodation down when it's offered to you or you're intentionally homeless. So the result of being far from your home in the approved premises may be that you end up permanently situated many miles away from your family. And this may be part of the answer to what my Lord Toulson put to me, that this is not simply a tiny incidental problem. It's a problem that may persist for very long periods of time. And there is evidence before the court, I'm going to show it to you shortly, that this may exacerbate mental health problems, may cause problems with dealing with vulnerabilities, re-establishing relationships, and establishing employment opportunities. Now, you can see paragraph 7 of Lord Justice Elias's judgment. He says, whilst a placement close to home is a realistic objective for most male prisoners, it's not achievable for female prisoners because of the limited number of APs made available for them. Then he says this, there's no different policy applied to women, but the lower demand for places in an AP limits their number. Now, again, with respect to him, I have puzzled over that sentence. And respectfully, it can't be right, because there is obviously a different policy. The policy is to provide far more APs for men than for women, and in far more locations. And in my submission, when you come later to his reasoning, which is essentially at paragraphs 39 and 40, it's tainted by that error. And then at paragraph 10, he describes the circumstances of Ms. Coll. And in that paragraph, he was somewhat dismissive with respect to him of the prospects that she would actually be released to an AP. There was no evidential basis before him to justify his a downplaying of the chances that she would be released to an AP. And in fact, it transpired that she was released to an AP. I don't propose to go to it, but for your note, it's in our written case. It's paragraph 16 to 17, where you'll see what actually happened to her when she was released. So that's the nature of APs. And then the next topic is the detriment suffered by women as a result of the restricted distribution of APs. Now, that detriment has been well documented and drawn to the attention of the Secretary of State, but no action has been taken by the Secretary of State at any time to investigate ways that that detriment could be removed or reduced. The starting point here is the seminal report of Baroness Corsten in 2007, a seminal study of the systemic disadvantages suffered by women in a prison system designed for men, in which they are marginalized as a small minority with exceptional vulnerability and different needs which are not being met. Now, the Corsten report itself is at part 2 of the appendix. It's page 247 of the appendix. It's page MS 345. And just to pick out some key passages, at the bottom of page 247 in the executive summary, paragraph 4, you can see the point about women being marginalised in a system largely designed for men. At 248, paragraph 5, she comments about the lack of action that's been taken under the public sector equality duty, which had recently come into force at that time. At 251, this is MS 349, paragraph 12, halfway through that paragraph, she talks about the nature of facilities for women, a small number of geographically spread prisons, the arbitrary re-rolling of women's prisons to cater for the demands of the growing male population, the lack of provision of suitable approved premises, especially for bail and particularly in rural areas, distance from home and family, frequent cross-border transfers, the wish of some women to settle away from their home areas and release to escape physically harmful relationships have resulted in women in the criminal justice system persistently being marginalised and their needs unmet. And then at 332, this is MS 430, a final word on costs. She says, an early task of the Commission for women who offered or at risk of offending in consultation with the Treasury will be to undertake a thorough review of the costs of my proposed recommendations. I recognise my proposals will require an initial outlay of funding. I do not believe it will be substantial when compared, for example, with the cost of a new prison build. I'm convinced my woman-centred approach will result over time in considerable long-term savings. Now, that's the first call for a review and for an attempt to be made to seek to identify the costs and benefits of making provision appropriate for women. Now, the next time that the problem was drawn to the attention of the Secretary of State was in the Joint Inspection Report, 2008. This is at page 352 of the same bundle. It's MS 450. So this is a joint inspection of approved premises carried out by the Chief Inspector of Probation, the Chief Inspector of Prisons, and the Chief Inspector of Constabulary. So a highly authoritative, independent report. And if I can just draw the court's attention to section 8 of this report, it's at pages 393 to 397 in the hard copy, 491 to 495 on the screen. I just invite the court to read the whole of that. I don't think we have time to look at it now, but can I draw the whole of that section to your attention?
female hostel estate has been diminishing for some time to the benefit of the men's estate.
That's right.
That's an interesting point.
That's right. But because they were taking what had previously been women's hostels, because they were under pressure for beds for men, and turning them to men's hostels. That's what happened to the London Women's Hostel.
Previously on page 251, you referred to, I think, passage in paragraph 12. And then there are some recommendations on the next page, page 252.
Yes.
In my copy, they're almost entirely illegible.
I know, my lord, I have the same difficulty. It's what happens when you copy something that's in colour. I'll get some colour copies brought for the court.
I'm not asking for the colour copies of the whole document.
No, but of the recommendations. It's essentially, you can see it's actually dealt with in summary in the Howard League's witness statement. Yeah. That Baroness Corston was proposing a wider geographical network of women's centres that would perform a variety of different roles, including the role of approved premises, a more flexible woman-centred approach. And my lady, you can see, if we go back to section 8, that at the end of that paragraph, it said it's not an acceptable strategy from the point of view of those women who meet the national criteria for hostel admission or those who have to manage their supervision, nor is it compatible with equalities legislation. And at 8.1.2, there is an explanation of the detriment. And then at 8.1.3, the number and location of locations of women perpetuated the discrimination experienced by women in prison, higher proportion than men forced to stay a long way from home, enforced separation from their families and support networks, compounded the problems associated with offending, relationships and mental health. 7 of the 100 mainstream hostels were for women. Now you'll notice there were 7 at this time. There are now 6. So at this time there was one in London. It was after this report that London hostel.
That's the King's Cross.
That was the King's Cross one.
Which is now a man's one.
That's right. That was
that
was re-rolled as a
hence
men's.
the
Yes.
expression for the benefit of the man's estate.
That's right. Now the respondents will say, oh well, it wasn't a very popular hostel. And the reason it wasn't a very popular hostel was because it was in the middle of a red light district and some women didn't feel safe there. But the answer is not to have no provision at all for women in London. And there's a lot of important material here, but I'm very conscious of the time, and I would just ask you to read the whole of this section 8, which, in the clearest possible terms, and using the language of discrimination, draws the Secretary of State's attention to the nature of the problem. And that is in 2008. And the summary you can see at 397, with the key findings and the recommendations. And if you look at the recommendations on 397, the second bullet, adequate and appropriate provision for female offenders meeting the national target profile for hostel accommodation is established within each probation region in the short term, and plans drawn up by NOMS to ensure reasonable access from all major centres of population by 2011. So that was the recommendation in 2008. Now, my lady, my lords, nothing was done. Nothing was done in response to this. This recommendation was never rejected, it was never accepted, it was never considered at all. The only response to this report was a probation circular that came out in 2008. And that is in the same volume of the appendix at page 442.
MS?
The MS is 540.
Thank you.
So you can see this is headed PC 16 2008, expanded use of female approved premises. And what is being suggested is simply an expansion of the criteria on which women can be allocated to approved premises so that they're more fully used. So that women who represent a medium risk could be accommodated there. And if you look at page 443, at the top of the page, they say the female APs are geographically scattered and are generally acknowledged not to be the optimum provision for female offenders. So this is well known to the department. And then the suggestion is that it could benefit those who represent a relatively low risk of harm. You see that in the third paragraph. And then the recent Corston review and the thematic inspection of APs, that's the documents we've just been looking at, concluded that the current female AP estate was unsatisfactory and recommended change. For the longer term, Public Protection Unit will be conducting a survey of the need for AP places, which will pay particular attention to the need for APs for female offenders. However, in the short term, we want to make greater use of the current female estate within the limits of what's safe and appropriate for female offenders. So what we're told here is there's going to be a longer term review. Then at the bottom of 443, they say it's acknowledged the present female APs are not conveniently located for many parts of the country. Distance from home and family connections can be a significant barrier to resettling offenders. Nevertheless, we encourage areas to consider AP placements where problems of distance are relatively small, or where those such problems exist, an AP placement would still be a more effective solution than custody. And then there is an equality impact assessment, which begins at page 445. And at the bottom of the page, over the page, you can see, under the heading Aspects that could contribute to equality or inequality, they say the policy should result in a better matching of interventions to offender need for some female offenders, as well as more efficient use of AP resources. This will have some effect on reducing inequalities in the way female offenders are treated compared with male offenders, but the scale of the likely change means the effect will not be significant. So there's an acknowledgement in these documents that there is an inequality in the way that women are being treated, and that what's being done here is not going to have any significant effect in mitigating or reducing it. And what's said is, well, there's going to be a longer term review. So what happened to that review? This was in 2008. By 2013, the review was still being promised. And we see that if we go to the appendix part 3, page 504, MS 602. This is a report by the House of Commons Justice Committee. You can see the title at page 500. Women offenders after the Corston report. So this is 2013 to 14 session, printed in July 2013. And in the summary, you can see that it's said in the third paragraph, there is little evidence that the equality duty and its forerunner, the gender equality duty, have had the desired impact on systematically encouraging local mainstream commissioners to provide services tackling the underlying causes of women's offending or informing broader policy initiatives within NOMS. So a failure to address the equality duty. And then if we go to page 560, that is MS 658, you see the heading, the review of the custodial estate. The Secretary of State announced in January 2012 a review of the female custodial estate due to report by summer 2013. Remember, this report was July 2013. To explore the most effective options for managing the female prison population. He subsequently told us the review of the custodial estate will be wide-ranging. He envisaged a blank sheet consultation on the future shape of women's prisons, indicating a willingness to consider a different model. She suggested it might compass consideration of a range of secure and semi-secure options, potentially including changes to the use of approved premises. For example, secure hostels rather than bigger institutions. The MOJ states the review will focus on current capacity, distances from home, and the future composition of the estate. Will also establish how the women's prison estate could be used to enable the government to realise its aim to nominate specific prisons as resettlement release hubs. It's unfortunate that we're reporting before the government publishes its response to the review. We decided on balance not to delay our report. So they were told this was imminent at this stage, and that it was going to address the specific problems that we're dealing with and look at the idea of having a larger number of smaller hostels with a better geographic distribution. Now, this this document also refers to the role of approved premises. If you go on to page 574, that's MS 672, and at paragraphs 192 to 193 discusses the potential for an expanded role for approved premises. and having a larger network of approved premises. Court can see that at 192. A larger network of approved premises could serve a dual purpose, could extend their existing role of offering staged introduction back to life outside prison to more women and used more extensively to prevent the need for women to be sent to custody in the first place. So there's a suggestion of an alternative to the current provision. And at 195, at page 576, they say they're encouraging the government's open to considering small custodial units. And then at 196, sometimes being required to live away from a home area can provide a break with a set of circumstances which, if a woman were to return to them, would be likely to perpetuate the problems causing her to offend in the first place. Having only 6 approved premises for women limits the number of women who can benefit from their constructive regimes and support. Now, the respondents have sought to rely on this to say, aha, it's good for women to be hundreds of miles from home. It's obvious in context that that's not what this is talking about. What it's saying is sometimes you have to take women away from their immediate home environment so they can benefit from the supervision of a structured regime. But what is needed is an expanded network of approved premises. So that was the situation at that time. We then received a witness statement in these proceedings from Sean Langley, which the court has in the core bundle. It's MS 232. This is September 2013 now, so this is some 2 months after the report we've just been looking at. Paragraph 9.8. To ensure the best value for money provision for the management of high-risk offenders on release from prison, NOMS has begun a review of how the AP service is commissioned, albeit that work on this has been put on hold pending the development of the Transforming Rehabilitation Programme. And then he says that the focus of the review, low down the paragraph, will be on ensuring we have sufficient provision for offenders who present a high or very high risk of serious harm. We know the level of demand from female offenders is low. We'll be giving separate consideration to the provision for female offenders. We'll analyse the demand and cost data separately for female offenders and make recommendations based on the findings. And that is where the matter rests. Nothing was ever done. The review remains on hold. It never came off hold. They never reported. They never did what they said they would do. They didn't even do what they said they would do after Mr. Justice Cranston made a declaration in these proceedings that they were in breach of the public sector equality duty. And so that is the evidential foundation for the unappealed finding of fact made by Mr. Justice Cranston, which is referred to in the Court of Appeal judgment at paragraphs 12 to 13, and which the court will have seen quoted in our case, that nothing has ever been done. Just very briefly show it to court. It's in the core bundle.
Well, if it simply says nothing has been done,
yes, well,
nothing has been done.
It specifically identifies what hasn't been done, my lord. It is MS 104.
But I can see, you know, the more you ratchet it up, the
Which is the page?
It's MS 104.
still says nothing will be done.
It says what is required is that he address possible impacts, assessing whether there's a disadvantage, how significant it is, and what steps might be taken to mitigate it. In the context of advancing equality of opportunity, one aspect of the duty, that means taking the opportunity to see whether more might be done for women, having regard to their particular circumstances. Nothing even approaching this has been done. So it's not simply that nothing has been done. Mr. Justice Cranston there identified the steps that ought to have been taken, but which hadn't. And not only has nothing been done, but there's never been any explanation from the Secretary of State as to why nothing has been done, even though the Secretary of State had been saying to the Parliamentary Committee that there was a review and they were about to report. Now, the detriment to women, the court will have already got a flavour of the nature of the detriment. Can I invite you also to look at the Howard League evidence, in particular paragraphs 3.11, 3.12 and 3.13. And in summary, we say that women are adversely affected by being placed away from their communities and families in various ways. First, they cannot see their children easily or at all in many cases. We have examples, for example, of women facing journeys 3 hours, 3-hour round trip to try to see their children, simply unfeasible, where they have to report regularly, where they will be subject to curfews. Secondly, that their mental health may suffer from separation from family and community. Thirdly, that they are likely to be allocated work and accommodation in the area of the AP, not where their family and community live, and that this may result in a long-term separation of the women from their families and communities. And this, as I've said, has now, in fact, happened to Ms. Coll. And we say that these detriments cannot simply be brushed aside as of no account on the basis that the average stay in an AP is relatively short. That's not an adequate reflection of the nature of the detriment that these women are suffering. And again, with great respect to Lord Justice Elias, at paragraph 6 of his judgment, the way that he expresses it, it's at MS 103, what we submit is a wholly inadequate reflection of the nature and extent of the detriment to women of being forced so many miles away from their families and communities, at a time when the whole statutory purpose of their accommodation is supervision and reintegration, rehabilitation. So that's the factual picture. And can I now turn to the law on sex discrimination? And the Equality Act is in volume 1 of the authorities bundle. It's at tab 4. MS 1832. Sorry, 1855. I beg your pardon. It's not tab 4 at all. It's tab 6. 1855 is the page number. And section 4, the protected characteristics include sex. Section 11 tells us that in relation to protected characteristics of sex, a reference to a person with a protected characteristic is a reference to a man or a woman. Then section 13 is the definition of direct discrimination. A person discriminates against another if because of a protected characteristic, so here because of her sex, he treats a woman less favourably than he treats or would treat a man. And then section 19 is indirect discrimination. A person discriminates against another if he applies to her a provision, criterion or practice which is discriminatory in relation to her sex. And the provision, criterion or practice is discriminatory if A applies or would apply it to persons with whom B does not share the characteristic. Now, that's a very important point, and it's one of the reasons why I'm going to submit that this is truly a case of direct and not indirect discrimination, because the essence of indirect discrimination is that the provision or practice is being equally applied to men and women. And we say that's absolutely not what's happening here. You have unequal provision. Now, you also have unequal need, which is what makes this case intricate. And that's why we have to look at Schedule 3. But that's why we say this is a case of direct discrimination. Then it puts or would put a person with whom B shares a characteristic at a particular disadvantage, puts B at the disadvantage, and A cannot show it to be a proportionate means of achieving a legitimate aim. So there is the general defence of justification to indirect discrimination. Then section 23, comparison by reference to circumstances, very important part of the principle of equality. You have to compare like with like. On a comparison of cases for the purposes of section 13, 14 or 19, there must be no material difference between the circumstances relating to each case. Now, that's very important when you come to look at the nature of the discrimination in this case, because if you're asking, has Ms. Coll suffered discrimination, her comparator would be a man who had been convicted of a similar offence and served a sentence, in relation to whom the parole board had said it was a condition of release on licence that he must reside in an AP, and whose family were living in London. Those are the material circumstances of Ms. Coll. And if you ask, would a man with those material circumstances be more favourably treated than Ms. Coll because of his sex? The answer is yes, because he would have the opportunity to be accommodated in an AP in London close to his children, and she would not. And the reason she would not is because of her sex, because there is no AP for women in London.
Are we looking at this case purely in terms of Ms. Coll, or are you mounting a more systemic challenge to the system? That's
well, if I may say so, extremely important question. And the answer is that it is a systemic challenge to the system. And that's why what I'm going to show to the court in a minute is the very important case of Birmingham City Council.
That's why it seems to me there may be a very big distinction between direct and indirect, why you may need to rely more on indirect than you were saying, because if you're mounting a systemic challenge, you've got the problem, haven't you, of, on one stream of authority, having to establish a complete identity between the protected characteristic and those who are at detriment. Now, you can do it in relation to Miss Coll, but you can't do it in relation to everybody. Whereas if you're looking at indirect, taking up Lady Hale's reference to looking at the substantive effect in the JFS case, there you're able to say, well, never mind that there isn't a complete identity, you can stand back and look at the broader picture, and here is this major discernible geographical trend. You'll no doubt develop that, but you're going to have to deal with the first point in relation to direct discrimination, and that's why I ask whether the attack here is one on system or Miss Coll.
Now, the point your lordship puts to me is the central legal question in this case that arises from the way that the respondent now puts their case. I'm obviously going to deal with it in detail, but my answer to it is that the cases, the line of case law that the respondents are talking about, like Pat Milnease, those are cases where the criterion is not the protected characteristic, it's something else. And so what the court is being asked to decide is whether the criterion for less favourable treatment is coextensive with and identical to the protected characteristic. This takes you back to James and Eastley, where the criterion for the difference in treatment on its face is gender neutral, it's pensionable age. But because pensionable age in itself involves less favourable treatment on grounds of sex, the answer is that that is direct discrimination. And you say the same thing in the Preddy and Bull case. Yeah. Because what happens in that case is that on its face, the criterion for less favourable treatment is not sex, it's marital status. But what Lady Hale says in that case is because you're discriminating between those who are married and those who have a civil partnership, that is coextensive.
That's why in that case, the majority of the view
that it's direct.
The necessary total congruence.
Exactly.
Both the majority and the minority appear to agree on the need for total congruence. I'm
now, my lord,
struggling with the total congruence in this case.
And the reason, my lord, is because this is a completely different kind of case. The criterion in this case is sex. What you have in this case is a lot of individual women, each of whom, as an inevitable result of the provision made by the Secretary of State, are suffering less favourable treatment on the ground of their sex.
But are there? Is the woman who lives in Reading suffering less favourable treatment on account of her sex?
Now, my lord, the point... This is a different point. It has never been the law that in
lots
order
of women are not discriminated against.
Exactly.
Lots of us are not discriminated against.
We are
that doesn't mean that there can't be discrimination against other women who are.
The ladyship has the point. Now, I don't want to get ahead of myself because this is the crunch point. Can I just set it up through the statute?
You'll have to deal with the early learners as well as the experienced.
I know, my lord, and your lordship is a far more advanced than I will ever be. But I want to take it in stages because, first of all, we need to understand the statutory architecture and then look at the Birmingham case, which is really the key case here. So that was section 23.
So you're going in due course to show us why it is enough for the purposes of direct discrimination to say generally women are going to be prejudiced by this configuration of the APs.
No, my point is more precise. My point, and I derive this directly from Birmingham, is that it is an inevitable result of the provision of APs made by the Secretary of State, which is less favourable for women than for men, that individual women will suffer less favourable treatment on the ground of their sex, because of their sex. I put it in those terms.
But not all women.
No, not all women, but many women.
Many women.
And when they suffer, and the point is this, when they suffer the less favourable treatment, they will suffer it because they are women. That's the point. And that's the distinction with the Pat-Mulnice principle. But can I come back to it? Because we need to look at...
Certainly.
Yes. So if we go to section 29, provision of services. So as the court knows, the way that this act works is first you get a definition of discrimination and then you get an enunciation of the circumstances in which discrimination is unlawful. And so here we're dealing with service provision. And a person concerned with the provision of a service to the public or a section of the public for payment or not must not discriminate against a person requiring the service by not providing the person with the service. And then a service provider must not, in providing the service, discriminate against the person as to the terms on which they provide the service by terminating the provision of the service or by subjecting that person to any other detriment.
You say this is a detriment case.
This is a detriment case, my lady. And then at 29.6, this is the specific provision we rely on, a person must not, in the exercise of a public function that is not the provision of the service to the public or a section of the public, do anything that constitutes discrimination. Now, I'm going to ask the court to underline those words, do anything that constitutes discrimination. And the reason why is because that language is identical to the language in the statutory provision that was at issue in the Birmingham case itself. The Birmingham case is of central importance here. Now, then the interpretation section that goes with section 29 is section 31, which is at page 1874. And simply draw that to your attention, and you'll see it's subsection 10 that Schedule 3 exceptions has effect. So we then go to Schedule 3. It's page 1884. And paragraph 26 of Schedule 3 deals with separate services for the sexes. Now, first general point to make about this, which is these statutory provisions are proceeding on the basis that if there was not an exception in these terms in Schedule 3, the treatment in question would be unlawful because it would be discriminatory. We say that's very important because it's clear that Schedule 3, paragraph 26 envisages precisely the sort of difficult situation that we are looking at, a situation where there has to be a single-sex service and where the needs of each of the sexes for that service are different. But the legislation doesn't say that's not discrimination. That falls outside the scope of the legislation. It says it is discrimination. It is direct discrimination, but exceptionally, it can be lawful if it's shown to be justified. Very important principle. So if we look at section 26, there are two different types of provision. The first is services that are separate but equal. So 26.1, a person does not contravene section 29 so far as relating to sex discrimination by providing separate services for persons of each sex. If a joint service for persons of both sex would be less effective, and the limited provision is a proportionate means of achieving a legitimate aim. So that's separate but equal.
Yes,
Now,
I mean, I have, looking at this last night, I puzzled about the word limited.
Yes.
In section 26.1, paragraph 26.1b, paragraph 26.2c.
Yes.
Where do they get limited from? I would have expected, this, we're talking about separate provision, I would have expected them to say the separate provision is a proportionate means.
My lord, I respectfully agree. Respectfully agree. And limited makes more sense in the paragraph we're looking at than it does in this subparagraph. And I think one has to read it as meaning separate.
Very well.
But
Limited to one sex or the other.
Yes, exactly. Limited to one sex or the other. But then we come to separate but unequal. 26.2. A person does not contravene section 29 so far as relating to sex discrimination by providing separate services differently for persons of each sex. So that tells you immediately that 26.1 is not talking about a situation where they're differently provided. That comes under 26.2. If, A, a joint service for persons of both sexes will be less effective, B, the extent to which the service is required, and just for the court to note, required includes, if we go back to section 31(6), a reference to a person seeking to obtain or use the service. So the extent to which the service is required by one sex makes it not reasonably practicable to provide the service otherwise than as a separate service provided differently for each sex, and the limited provision is a proportionate means of achieving a legitimate aim. So what we're being told here is if the sexes have different needs for a particular service, that doesn't mean that providing it differently is no longer sex discrimination. It is sex discrimination. Neither does it mean that the service provider can simply say, well, the need for the service is different, therefore it's justified to provide it differently. That would mean stopping at B. The legislation requires you to go on from subparagraph B to C and requires it to be established that the limited provision is a proportionate means of achieving a legitimate aim. Now, this means that not only must you show that the needs are different and that therefore it's legitimate to have different types of service or services provided differently, but you must also show that what you're doing is proportionate. And that means, of course, that the discriminatory effect has been weighed against the costs and benefits of the provision of the service. And it means also that proper consideration has been given to alternative methods of providing the service that would have a less discriminatory effect than that which has been selected. There's an obligation on the service provider to think of other ways that the disadvantage could be mitigated. And my essential submission is that what this section provides is a perfectly workable scheme for a competent government department to operate an AP system in a world where the great majority of those who require it are male rather than female. But what it does not permit is an incompetent, with respect, government department who has been told over and over again that the way they're operating the system is causing serious systemic disadvantage to women and have done nothing at all to investigate the costs and benefits or availability of alternatives or the extent of the detriment that's being suffered, because that department fails the proportionality test. And we say that it's very clear when you look at paragraph 26 that Parliament intended that precisely the type of treatment that we're concerned with here would be treated as direct sex discrimination, but that it would, very unusually, be capable of being lawful if shown to be justified. The final provision I need very briefly...
But paragraph 26 is an exception
yes.
from what would otherwise be both direct and indirect discrimination.
Your Lordship's right. Your Lordship's right. And of course, if I'm wrong on my primary submission, then we end up in precisely the same place, because we would end up in any event in 26.3. Now, we say one of the flaws with respect, in my learned friend's printed case, is to suggest that in some way what has to be justified if this is indirect discrimination is different from what has to be justified if it's direct. It actually doesn't matter to the result in this case. It makes no difference whether this is direct or indirect discrimination, because section 26.3 would apply in any event. So what has to be shown to be proportionate is the limited provision in either event. That's what the focus of the statute is on. And before we leave this, at 26.3, this paragraph applies to a person exercising a public function in relation to the provision of a service as it applies to the person providing the service. And it's now accepted by the Secretary of State that she is covered by this provision. Now, the only other provision in the Act I just very briefly want to flag is the Public Sector Equality Duty, section 149. That's at page 1882. And there is a finding in this case, of course, that duty has been breached.
So which page? I'm so sorry.
Sorry, it's page 1882.
This is what the declaration relates to.
There is an extant declaration that the Secretary of State's in breach.
Yep.
But the Secretary of State has done nothing whatever to remedy the breach. And one of our points on this appeal is that there is an inherent inconsistency between the courts saying The Secretary of State's done absolutely nothing to investigate the extent of the detriment or seek to remedy it, and that means that there's a breach of the public sector equality duty. But then to say the Secretary of State's able to justify the discrimination. The Secretary of State's not in a position to justify the discrimination because she has no evidence with which to do so, either at the time or ex post facto. And of course, the effect of the court saying that there's a breach of the public sector equality duty, but the discrimination is justified, is that the Secretary of State has taken that as carte blanche to say, well, I don't need to do anything, because the court's already endorsed the current provision. I don't need to do anything. And the result has been more than 3 years of complete inaction. Now, that then takes me to the very important case of Birmingham City Council, which is in Volume 1 of the Authorities Bundle. It's tab 9, one of the absolute seminal cases. And this was a judicial review brought by the Equal Opportunities Commission of the provision that was made by Birmingham City Council for grammar school places for boys and girls. And for historic reasons, Birmingham had inherited a situation where there were more boys' grammar schools than girls' grammar schools and more places for boys than girls. As a result, if similar numbers of girls applied and took the 11 plus, then it was likely that girls would have to score higher marks to get places. I would add it was not certain, because of course it would depend on the overall performance of the cohort and how many girls and boys there were in the cohort. So if we're looking at the exact equivalence criterion, you couldn't show that it was satisfied here because it would depend on the particular circumstances year by year. The case is similar to our case for a number of important reasons. First, like the case that this court is considering, this was a judicial review of the overall provision made by the council, brought by the Equal Opportunities Commission, although in this case, of course, Ms. Coll is also now a victim of the policy. At the time she brought her claim, she simply feared that she would become a victim of the policy. Second, the statutory provision that was under consideration in the Birmingham case is very similar in its wording to the statutory provision that's in issue in these proceedings. And third, the local authority provision of grammar school places was not the result of any deliberate policy to disadvantage girls because they were girls. On the contrary, the council was very keen to improve the quality of opportunity for girls. It was simply the result of a historical accident, as in this case, the piecemeal development of APs. And the leading speech is given by Lord Gough and starts at page 1963.
I'm sorry, Miss Rose, I didn't make a note of your second proposition.
The second proposition was
A second similarity, I mean.
Very similar statutory provision.
I was going to ask, can we see that?
Yes,
You'll be showing it to us.
I'm going to show it to you, my lord. Yes.
Thank you.
So if we go to the speech of Lord Gough, it's at page 1963. He records the disparity on that page. And at 1964, he talks about the effect of the disparity. He says that the table shows that girls with a test mark near the borderline have a substantially smaller chance of obtaining education at selective schools in Birmingham than do boys with comparable marks. And that's why I made the point that there isn't a coextensive detriment here. There are girls who will get in and those who don't, depending on year on year. But those who don't get in will not get in because they're girls. That's the point. Now, he then describes the various options that were open to the council. That's at the letter D on that page, all of which were somewhat unpalatable. And at page 1965, at A, he says, there's no doubt the council faces great difficulties in the way of solving the problem of disparity between the sexes at selective secondary schools. However, it has to be said, whatever the difficulties may be, there's no evidence that council has sought actively to overcome them. And then the statutory provision is at page 1966. it was what was at that time Section 23(1) of the Sex Discrimination Act. It is unlawful for a local education authority in carrying out such of its functions under the Education Act as do not fall under Section 22 to do any act which constitutes sex discrimination. And the court can see immediately the similarity in wording to what is now Section 29(6) of the Equality Act, which is the section we're concerned with in this case. Now, also in play was Section 25, which you can see set out on the same page. And Section 25 was a precursor of what's now the public sector equality duty. It laid down a general duty on various different bodies to eliminate discrimination and promote equality of opportunity in education. And part of the argument that was being made on behalf of the local authority in the Birmingham case was that this was a case properly to be considered under that provision, which could only be enforced by the Secretary of State, not by the EOC, and that it didn't fall within the prohibition of discrimination under Section 23. And that was one of the arguments that Lord Gough rejected.
I understand your point that the fact that some girls did well enough they get through anyway didn't mean there wasn't discrimination.
Yes.
In that sense, therefore, there didn't have to be total congruence. Can I just think through the consequences of that in relation to our case? Really by reference to the example that Lord Justice Elias takes in UPU, where he says, what about the situation where a man happens to be further away from the AP than a woman would be? I think it follows, doesn't it? You'd say, well, indeed, there is sex discrimination in that case against the man. It may be that it could be marginal if, in fact, there was somewhere quite close for him. That's a point of detail. But it may be, from the male's point of view, much easier for the Secretary of State to justify. But all that arises at the justification stage. Truth is, once you've got these different categories for men and for women, there is necessarily direct discrimination towards both sexes, albeit in different numbers, and then you turn to the justification. Have I got the logic correct?
Your Lordship has the logic correct. That we say is the scheme of Schedule 3, paragraph 26.
Yeah.
And what your Lordship's just put to me, you will see set out in our printed case.
Thank you.
And there are a couple of points to make. The first point to note is that there is no town in which there's a women's facility but not a men's facility. Right. So there's no situation...
Hypothetically, if there were...
Hypothetically, if there were, your Lordship's right.
Yeah,
that if there were women's facilities in areas of the country where there weren't men's facilities, you could get the same situation in the
Because Lord Justice Elias was dealing with a hypothesis.
Yes, what he hypothesised was a man who whose family lived next door to the women's facility in Reading, and his family lived the other side of Reading. And that's why we also make the point that there's probably no detriment at all in that situation.
You say that's trivial.
Exactly. It's hard to see it as a disadvantage that would reasonably cause concern. But the ultimate answer is the answer that your Lordship has put to me. Now, so if we then look at the detail of the Birmingham case, and first of all, the point, this is still on page 1966, the point is taken that there's no less favourable treatment on grounds of sex, and on two bases. First, because you couldn't say that single-sex education was necessary, that selective education was necessarily better. And secondly, that it had to be shown there was less favourable treatment on the grounds of sex, which involved an intention or motive on the part of the council to discriminate against the girls. Both of those arguments rejected, because the deprivation of the same opportunity as the boys, as you can see at H, an opportunity valued by them, or at least by their parents, obviously valued on reasonable grounds, was less favourable treatment. And then over the page at 1194, there's discrimination under the statute if there's less favourable treatment on the ground of sex. In other words, if the relevant girl or girls... So here your Lordships will note, this is a challenge to the provision by the council, but when asking whether there's discrimination, what Lord Gough looked at is the situation of individual girls and says, if the relevant girls would have received the same treatment as the boys but for their sex. So in order to discern the discrimination, you look at it from the perspective of the individual girls. And we say that exactly the same logic applies in this case. And then Lord Gough says, I now turn to the most substantial issue in the case. This is at the letter E. This turns on the true construction of Section 23 of the Act of 75 and its relationship with Section 25. And he then describes the argument which Mr. Beloff had developed, saying that in reality this was a Section 25, i.e. proto-public sector equality duty case, and not a Section 23 case. And in particular, at 1195, it's 1968 at the bottom, at C, Mr. Beloff sought to support the conclusion of Lord Justice Wolfe in his dissent. Now, I would invite the court in due course to read the dissent of Lord Justice Wolfe because it shows striking similarities to the way that the case has been put in part by the respondent in this case. And he focused on the word constitute. If you see it, F, he concluded that having regard to the wording of Section 23, a breach under that section only occurred where the local education authority did an act which constituted sex discrimination, i.e. not only resulted in sex discrimination, but itself involved sex discrimination. And then there's the quote, whether it's implementing a policy that's discriminatory or deliberate failure to take a decision. He says only in those circumstances would there be discrimination by the authority. That argument was rejected. So if you go over the page at 1196, you see just under C, there's the rejection of the submission. And then at G, very important passage on which we rely, for these reasons, I find myself in agreement with the conclusion of Mr. Justice McCulloch and the majority of the Court of Appeal. I agree with the general conclusion expressed by Lord Justice Dillon in the following passage. In truth, the Council's position really is that they are knowingly continuing their acts of maintaining the various boys and girls selective schools, which inevitably results in discrimination against girls in light of the great disparity in the numbers of places available, because the only alternatives open to the Council are unattractive or difficult to apply. We say that that reasoning applies directly in our case to a strikingly similarly worded statutory provision.
What was the order that was made? It had been made by the Court of Appeal.
There was a declaration made.
1930, well, 1157 in the report, MS 1930, has the declaration at letter D, and that we're told that Mr. Justice McCulloch made the declaration as sought.
I'm grateful.
That's the end of that paragraph, just above letter H. Mr. Justice McCulloch, upheld the Commission, granted the declaration sought.
There was an order for mandamus.
No, mandamus was not granted.
But the declaration was that the arrangements made by Birmingham City Council were unlawful pursuant to, etc.
So there was no order for mandamus.
There was no order for mandamus. Mandamus was sought, but I don't think a mandamus was granted. Now, so we say that it's exactly the same situation here. And of course, we make the point with even greater force because Parliament enacted the 2010 Act in the knowledge of this decision of the House of Lords and used the same language in 29(6), an act which constitutes sex discrimination in the performance of a public function, which was the language being specifically construed by Lord Gough in approving Lord Justice Dillon in this passage. So we say that if, as here, the provision that's made for APs inevitably results in discrimination against women because of their more limited distribution, then that is a breach of 29(6) and it's direct discrimination. The key difference...
It was a rather different situation, wasn't it, in Birmingham? Because you basically had roughly equal numbers of able boys and able girls. Obviously, yes. It would vary with the individuals. And you had grossly unequal provision of education designed for the more academically able children.
Yes.
The problem that we have in this case is that we don't have equal numbers. We have far fewer women prisoners requiring this sort of provision than we have men. Yes. And in fact, if anything, there's over-provision. believe, is there not?
Well, it's not clear. There's lower occupancy, but that may not be because there's over-provision. It may be because of the locations.
Yes, exactly.
The criteria for women are broader than the criteria for men. Nobody complains about it.
No, nobody complains about it.
No.
But your ladyship's right. Your ladyship's right, and that's the complicating factor in this case, and that's the factor that's specifically catered for by Schedule 3, paragraph 26.2, because 26.2 specifically envisages that situation where there is a difference in need, and says you have to go through the hoops of showing that there is a difference in need and of showing proportionate justification. But the central question, that's why I said at the outset, it's very important in this case to distinguish between the factors that are relevant for establishing the existence of discrimination and the factors that are relevant for establishing justification. Because the discrimination is established by the satisfaction of this test devised by Lord Justice Dillon. What we then come on to is the question of justification. And that, of course, is different from the situation in Birmingham, because in Birmingham there was no defence of justification available to the council. The mere fact of the inequality of treatment was sufficient to make their discharge of their function unlawful. So, my lords, my lady, that's what we say is the reason why there is direct sex discrimination in this case, why it must therefore fall to be unlawful unless the Secretary of State can satisfy the test under Schedule 3, and that he cannot satisfy the test because he's done nothing to begin to satisfy the test of proportionality. So that's why we say we win. So what is it that the respondent says about this analysis? And the case that's now being advanced is summarised, if I can invite the court to take up the Coll volume and the printed case of the respondent, which starts at page 59 in the Coll volume. And the way that the respondent puts it is at 4b. This is a summary of the way the respondent puts it. It said, being placed in an AP far from one's home could, in principle, constitute less favourable treatment within Section 13. But the detriment is not suffered by all women and not suffered only by women. Now, pausing there, my answer to that is going to be that it is not necessary, in order to show sex discrimination, to show that a detriment is suffered by all women or that it's suffered only by women.
That's the complete congruence point.
Yes, but we say that the test is whether the treatment is suffered because of sex, not whether it's suffered by all women and only by women. There are many situations in which some women will suffer discrimination on grounds of their sex and some won't. Birmingham City Council is an example. There will be lots of girls who will have passed the 11 plus and lots of boys who will have failed it. Now, then, there is no exact coincidence between the protected characteristic and the criterion applied, and that's the point I'm going to come back to now and deal with in detail. And then it said this: if a woman is placed in an AP far from her home, that will be because her home happens not to be in an area with a woman's AP, not because of her sex. Now, in my submission, that sentence really shows you the flaw in the respondent's argument. How can you possibly say that to refuse somebody a place in an AP because there happens not to be a women's AP in their area is not treating them less favourably because of their sex? The existence of the term the women's AP gives the game away. It's because she is a woman that she can't get a place in an AP. There's a men's AP in the area, but not a women's AP. So we say that we can see here the fallacy. And if you take Ms. Coll's own situation, a woman whose family are in London, she's required to reside in an AP. If she were a man in exactly the same situation, she could be placed in an AP in London. Because of her sex, she cannot be. That is direct sex discrimination. So what the respondents are saying is based on the perfect congruence analysis. And they found that essentially on the decision in Hall and Bull, and the cases that are referred to in Hall and Bull, and we need to look at that case. It's at Authorities Bundle 3, tab 33. It's MS 2679. So this is the case of the gay couple who were in a civil partnership who were refused a double room in a bed and breakfast. And the bed and breakfast proprietors said that this was not discrimination on grounds of sexual orientation, it was because they were not married. And they would only give a double room to a married couple, and unmarried heterosexual couples would be treated in the same way. So the issue that was live in this case was whether the criterion that was being applied, which was not on its face sexual orientation, but something else, should be treated as equivalent to, coterminous with, sexual orientation. Because on the face of it, the criterion was not sexual orientation, but marital status. And that's why this case is similar to the James and Eastleigh Borough Council case, where on the face of it, the criterion was not sex, but was pensionable age. So both of these cases are identified as cases of direct discrimination because although the criterion is not overtly sex or sexual orientation, on analysis, the criterion necessarily involves less favourable treatment on grounds of sex or sexual orientation. Neither James, nor this case, nor Pat Monnies, nor any of the other cases, has any bearing on a simple case like this appeal, where the reason for the less favourable treatment is sex, not anything else, which you have to ask, is it coterminous with sex? It's just sex. The reason why Ms. Coll can't be placed in an AP is because she's a woman. There's no other reason given. So the complexity that's analysed in these cases simply does not arise in our case. And if we go to Lady Hale's judgment, paragraph 16, we see the heading direct or indirect discrimination. And we can see the way the case was put at paragraph 17. Mr. and Mrs. Bull state that they did not discriminate against Mr. Preddy and Mr. Hall on the ground of their sexual orientation, but on the ground that they were not married to each other. They've applied exactly the same policy to unmarried opposite-sex couples. And then paragraph 19, Her Ladyship cites Advocate General Sharpston in Bressol. I take there to be direct discrimination when the category of those receiving a certain advantage and the category of those suffering a correlative disadvantage coincides exactly with the respective categories of persons, distinguished only by applying a prohibited classification. Now, I would not disagree with that formulation, but that's not the only situation in which direct sex discrimination arises. Direct sex discrimination also arises where a woman is treated less favourably because of her sex. And then what's said here...
You only have to go into this question.
Exactly.
Where the overt criterion is not the protected characteristic.
That's the point.
When the overt criterion is the protected characteristic, you don't have to bother with all
Correct.
of it.
Yes.
That's the answer.
Yes.
Now, I could sit down now, but I'm not going to.
No.
But that is, in fact, the answer. And you can see it very clearly in the next quotation from Your Ladyship's judgment here, from Schnorbus. The discrimination is direct, where the difference in treatment is based on a criterion which is either explicitly that of sex or necessarily linked to a characteristic indissociable from sex. And our case is the former, not the latter. This was the latter, and the answer that was given was this was indissociable from sex because there was discrimination as between those who were married and those who were in a civil partnership. And for those in a civil partnership, that was based on their sexual orientation. Just for the court's note, it goes down to paragraph 29, and so it's all of the paragraphs from 19 we've just been looking at, down to 29. So we say our case is the simple case where none of this reasoning arises. It's the case where, to apply Lord Justice Dillon's language, the Secretary of State is knowingly continuing her acts of maintaining the various APs, which inevitably results in discrimination against women in the light of the great disparity in the number of APs available and their location. And that's the application of Lord Justice Dillon's reasoning. Now, my lady, my lords, it has never been the law that a woman who's suffered less favourable treatment because she's a woman cannot succeed in a claim of direct discrimination unless she can show that the discriminator treats all women less favourably than all men, which is the proposition for which my learned friend contends. Just to give an example, let's look at the Roma rights case. In the Roma rights case, this is another case, by the way, of a judicial review of systemic discrimination, brought in that case by the European Roma Rights Centre, another case in which a general declaration was made that the system that was in operation at Prague Airport discriminated on racial grounds. What was happening was that British immigration officers had been posted at Prague Airport and they were giving leave to enter or refusing leave to enter on the basis of interviews conducted at Prague Airport. And what they were seeking to do particularly was to weed out potential asylum seekers. And because in the Czech Republic, the great majority of those likely to be seeking asylum were Roma, what in fact happened was that people who looked like Roma, who were detectable from their physical appearance, were subjected to much more intrusive questioning and were much more likely to be refused than non-Roma. It was a racial stereotyping case. And the House of Lords in that case ultimately made a declaration that the system was being operated in a discriminatory way. Now, the Roma rights case is at the volume 2 of the authorities bundle. It's at tab 20. And it's another speech of my lady.
That's not necessarily the best way of persuading my brethren that that's the correct... No.
My lady, I can't help it that your ladyship's made the leading speeches in this area. We'll have to live with that. It's at page 2320. The facts of the Roma rights case were not that all Roma were refused and all non-Roma were admitted. The court can see that at paragraph 92, page 2320. The evidence was that 68 out of 78 Roma were turned away and only 14 of 6,170 non-Roma were rejected. So there were certainly some non-Roma who were less favourably treated than some Roma, because some Roma were given leave to enter when some non-Roma were not. That didn't stop this being a case of direct race discrimination, because those of the Roma who were being refused because they were or were perceived to be Roma. It was because of their race that they were being refused permission. And the fact that not everybody who was Roma or who was perceived to be Roma was being less favourably treated on racial grounds didn't stop this being a case of direct race discrimination. And the systemic discrimination, if I can just refer the court to paragraph 97, it's not the object of these proceedings to make a finding of discrimination in any individual case. The object, as Mr. Justice Burton pointed out, is to establish a case that the Prague operation was carried out in a discriminatory fashion. All the evidence before us, other than that of the intentions of those in charge of the operation, which intentions were not conveyed to the officers on the ground, supports the inference that Roma were, simply because they were Roma, routinely treated with more suspicion and subjected to more intensive and intrusive questioning than non-Roma. There's nothing surprising about this. The Court of Appeal considered it wholly inevitable. This may be going too far, but setting up an operation like this, prompted by an influx of asylum seekers, overwhelmingly from one comparatively easily identifiable racial or ethnic group, requires enormous care if it's to be done without discrimination. That did not happen. And then the inevitable conclusion is that the operation was inherently and systemically discriminatory and unlawful. Now, obviously, there's a big difference there, because the type of discrimination we're talking about is racial stereotyping. But the point that I make is that in this case, what you have is the systemic provision of less favourable facilities for women, which results in the inevitable discrimination against individual women because they're women. When you look at this case together with the Birmingham case, both of them judicial reviews of a system, we submit that the answer in this case becomes clear. But bear in mind, on the respondent's logic in this case, if there were not a disparity in the number of women in the system, if there were 50% women and 50% men, and the configuration of the approved premises still looked like this, on my learned friend's case, there would not be direct sex discrimination. Because on his case, the fact that some women would still be closer to the relevant AP than some men would mean there was no direct discrimination. We submit that cannot be right. It's quite obvious that there is a less favourable provision being made for women than for men. Now, the matter's complicated because of the different level of need, but that's what takes you to Schedule 3 into the question of justification. So if we then pick up the respondent's written case again and see the detail of their reasoning, if we go to paragraph 47, page 79, they say that we don't complain about the policy of providing men's and women's APs separately. That is, of course, correct. They say the complaint is women required to reside in APs are much more likely to be placed in AP many miles from home. Remains the case some women will be placed in APs close to their homes, some men in APs outside their home area. So we say that is true, but has no bearing on the question of the reason why the women who are disadvantaged are disadvantaged.
That's essentially the same argument as in 4B.
That's right. And you see it at 48A, they seek to apply the Bressel test based on the correlative disadvantage coinciding exactly. And we say that's simply the wrong test. That doesn't apply here. The misunderstanding of the law. And then at B, the current configuration of APs will necessarily be beneficial for some women and detrimental for others. Well, that may well be true, but it's irrelevant. We don't have to show all women are equally disadvantaged. The question is not whether all women are disadvantaged, and neither is it a comparison between the relative advantage of some women against others. The question is the comparison of the treatment of individual women and the treatment of individual men. Then at C, they say it's true that a prisoner's eligibility to be placed in a particular AP depends on his or her sex. That flows from the unchallenged policy of providing men's and women's APs separately. The appellant's not complaining about the failure to allocate her or women generally to any particular AP. That, with respect, is a mischaracterization. What we're complaining about is the failure to make any provision for Mrs. Coll in the London area where her family reside. That's her particular complaint of discrimination. And that's a complaint of discrimination replicated by women all over the country, women in Wales, women in East Anglia, women in the Southwest, for none of whom there is any provision in their local area. So yes, they don't complain that they can get into any particular AP, they can't get into any AP in their local area because the only local APs are for men. And then over the page, at page 80, what is said is, she's complaining about the failure to allocate her and other women to an AP close to home. The two facts that determine whether she'll be placed in AP close to home are, one, the location of her home, and two, the location of the women's APs. Now, there's some confusion here, because the first of these is what goes to the question of what are the material circumstances that apply in her case. If you're asking if she's been less favourably treated than a comparable man, you have to choose a man whose home is located in the same area and ask, is she being less favourably treated than him? So it's not right to treat it in that way, we say. The second is the location of the women's APs. And that, of course, is the discrimination about which we complain. What is then said is the latter is, of course, within the control of the Secretary of State, but it's not suggested that the decision about where to place women's APs is made on the basis of sex. As Lord Justice Elias noted, there was no decision to locate women's APs in as remote a region as possible. Now, that is the final flaw in the analysis of the respondent, because this is a return to the analysis of intention or motive to discriminate, which is the very foundation of the decision in Birmingham. That is the argument that was rejected by the House of Lords in Birmingham, and rejected by reference to a virtually identically worded statutory provision. It doesn't matter whether Birmingham intended to discriminate against girls. Had no intention of doing so. They inherited an unequal provision, the inevitable result of which was that girls suffered discrimination. That's the point. So we say this again is an error of law at paragraph 48. And so for those reasons, we submit that the respondent's answer to this appeal is incorrect. Now, the flaws in the Court of Appeal decision I don't intend to address separately. Can I simply refer the court to our written case? It's paragraphs 36 to 47 of our written case, and the court will find the key errors in the Court of Appeal's judgment at paragraphs 39 to 40 of that judgment. The court there mischaracterises the policy, says that an equal policy is being applied to men and women to place them as close as possible to their homes. We say that's simply a mischaracterisation of the situation here. And then there is the hypothetical example that I've discussed with my Lord Toulson. There is also at paragraph 41 a rejection of this case on the basis that it's not an individual claim, but a judicial review. And again, the court has our answer to that in our written case by reference to the Refugee Legal Centre, to the Roma Rights case, and to the Birmingham case. It is perfectly appropriate and legitimate to bring proceedings for judicial review based on the fact that a system is operating in a systematically discriminatory fashion. That brings me then to the question of indirect discrimination. It is difficult to analyse this case in terms of indirect discrimination. And the reason that it's difficult is because, as we've already seen from the statute, one of the essential elements of indirect discrimination is that there must be a policy, practice, or provision which is being applied equally to men and women. And the whole essence of the problem here is that the policy or practice or provision is being applied unequally to men and women. There's far more provision being made for men than for women. The whole point of our complaint is that the provision of APs is unequal. It's very different. So in a struggle to shoehorn this case into an indirect discrimination analysis, we've identified a policy criterion or practice, which is simply the requirement for a person with a license condition requiring them to reside in an AP to reside in an AP. And we say that that has places women at a particular disadvantage because of the distribution of APs. So that's our alternative analysis, and you find it at paragraphs 49 to 50. As I've said, we maintain it, but my primary submission is that this is a case of direct discrimination.
Now, Lord Justice Elias said, well, that won't do, because if you identify the PCP in that way, it's innocuous. You say, I imagine, that is to shut your eyes as to the real picture.
Exactly.
And that in looking at whether it's innocuous or not, you need to look at its practical effect. Lady Hale's remark that in the JFS case, you're looking at substantive effect.
Yes, my lord.
And therefore, you say he had the compass too narrow.
Yeah, yes, my lord. That's
your case on indirect, therefore, is that everybody is required to, everybody falling in this category of offender is required to live somewhere. Its substantive effect is discriminatory.
Yes.
Because as things are currently configured, the necessary corollary is that certain people will live so far away from their family that they're unable to communicate or visit their children, etc., etc.
Exactly. Exactly right, my lord.
That's how you put the case.
That is exactly how we put the case, yes, my lord. And we then say that the test for justification is exactly the same, whether you analyse this as a case of direct or indirect discrimination, because, as has already been put to me earlier this morning, Schedule 3, paragraph 26 applies generally to discrimination in the provision of services. and is in play, however you characterize it. So whichever way you look at it, what has to be shown to be a proportionate means of meeting a legitimate aim is the limited provision that's made in this case for women, however you look at it.
Of course, the courts below said that the discrimination issue wasn't reached.
Yes.
But that if it was,
Yes.
It was justified.
That's right.
Are you saying, basing yourself on the declaration about the public sector equality duty, if you're saying that Mr. Justice Cranston had found that that duty was breached and made a declaration which wasn't disturbed or sought to be disturbed in the Court of Appeal, that you couldn't go on to say justified?
My Lord, I don't put it that highly because, of course, you can have cases in which there could be a breach of the public sector equality duty, but then ex post facto, the Secretary of State could produce evidence to the administrative court or the High Court or whatever to say, in fact, we can now justify this treatment. And it's well established from cases like Elias that you can have an ex post facto justification. Indeed, Brewster says the same. You can have ex post facto justification of discrimination. What is so stark and so striking about this case is that the position that Mr. Justice Cranston recorded in that finding of fact has remained the position throughout. And at no stage has the Secretary of State ever sought to put forward any evidence that any of the actions identified by Mr. Justice Cranston has been done or that there are any conclusions from them. That's the point. That the breach was done, but there was never any attempt to put forward any further evidence to justify, and it's that particular position. Now, the respondent's case here doesn't very clearly enunciate a legitimate aim, and I await with interest to hear from a learned friend what they say the legitimate aim is. We have criticised the aims that were identified by the Court of Appeal, which were essentially cost savings and having equal provision for men and women. That's in our written case at paragraphs 57 to 65, and I don't propose to go to it. I do just want to deal briefly with proportionality. We say, I'm aware of that, my lady. I'm going to go very rapidly through this. We say that the test that applies here is the classic Bilker-Kaufhaus test. The court has before you, we've put forward this morning the judgments in Homer. It's set out at paragraphs 19 to 20 of that case. The very recent decision in Brewster at paragraph 66 gives another formulation. But the key points are that, first of all, of course, a legitimate aim must be identified. Secondly, it must be shown that it's sufficiently important to limit the equality right. Then it must be shown that there is no less discriminatory alternative reasonably available. And finally, the extent of the disadvantage to the individuals adversely affected must be weighed against the importance of the aim pursued. And we say the Secretary of State cannot hope to succeed in this case because the third and fourth elements she is in no position to satisfy, because she's never sought to even explore or investigate what less discriminatory alternatives could be adopted that would mitigate the disadvantage to women, and neither has she ever sought to measure the extent of the detriment to them.
In your notice of appeal, I'm not sure it appears in the case, but I want to check if it's still your position. In your notice of appeal, Coll MS, page 13, paragraph 47, you said the limited provision of women's APs might be capable of justification in the future once such issues have been investigated and evaluated by the Secretary of State, but it couldn't be shown to be justified on the evidence before the court and on the findings of fact made by the administrative court.
Yes.
Does that remain your position?
Yes, of course, because it has to be our position, my Lord, because the position is that there's simply a lack of evidence.
Yeah.
And so we can't say conclusively whether it's capable of justification. And indeed, there's nothing unusual about this. In any case where a particular measure is shown to be unjustified, if circumstances change or more evidence becomes available, it could be justified in the future, because justification is essentially a question of evidence. But this case is so stark because of the total lack of evidence. Now, I just want to very briefly, before I sit down, address the way that the respondent puts this in her written case. paragraph 73. Sorry, before we come to that, briefly, paragraph 71, the way that the test is formulated, this is page 87. First of all, they dispute that the legitimate aim must be shown to be unrelated to discrimination based on sex. We say they're wrong to dispute that. You can't ever justify sex discrimination by an aim that's related to sex discrimination. Then at 71B, they make the usual plea for a wide margin of discretion for the exercise of a public function. We say that's inappropriate in this case for two reasons. First, this is a breach of the statutory duty not to discriminate under section 29(6) of the Equality Act, and the provision for justification at Schedule 3, paragraph 26, applies equally to service providers and to those exercising a public function in relation to the provision of a service. There's no basis for interpreting the statutory requirement for justification any differently in the case of a public service provider and anybody else providing a service. This is hardcore statutory discrimination, not open-textured human rights violation. The second reason why we say it's inappropriate is because of the lack of any consideration of the relevant questions at the time, and the court will have in mind the cases I've shown. And this, of course, was recently reaffirmed by this court in the Brewster case itself, that having not considered the matter at the time, you cannot then pray and aid a margin of discretion. And if we then go over the page to the application of the test to the facts, the key points, the point is made at C, is that the only way of making placement in an AP close to home equally likely for women as for men would be to increase the number of women's APs, so equal the number of men's at 94. Now, we simply don't, first of all, we don't know if that's right or not, because there are alternative ways that this could be done, and the court will be aware of for example, of the Corston proposals. But even if that were true, and there's no evidence to support it, even if that were true, we don't have to show that there's another method that would place women in an equally favourable position to men. The question is whether there are alternatives that would reduce the adverse effect, reduce the discriminatory effect of the current provision on women. It's a mitigation, it doesn't have to be an elimination. Then at D, they say that if they were to have 12 APs, women would still be much more likely than men to be sent to an AP far from home. Their capacity would drop to 9 and the annual running costs would double. Now, again, these are bare assertions based on basic information about the costs of running an AP, but with no consideration of alternative ways that the provision might be made or of countervailing savings. And since the Secretary of State's never even attempted to assess what savings could be made, she's in no position to answer that question. And at E, it said the provision for women would be materially different from the provision of men in either of these scenarios. That's true. But of course, Schedule E, paragraph 26(2), is specifically envisaging different provision for women than for men, where their needs are different. The key point is ensuring as far as possible that the provision is not less favourable. It doesn't have to be identical. That's a very important point. And then there are some assertions here that there would be a higher staff-prisoner ratio, the staff would have less experience, and the residents have little, if any, opportunity to interact and experience greater isolation. With great respect, this is a little cheeky because there is no evidence to support any of these propositions. This is pure assertion by argument, unsupported by evidence, and the reason it's unsupported by evidence is because the Secretary of State's never investigated it. Then they say at F that you shouldn't overstate the disadvantage. The court already has my submissions that in fact the disadvantage has been understated by the courts who consider this below. It is a significant disadvantage. And then at 74 they say this: these factors support an objective justification. The court should accept it even without a quantitative analysis of the claimant's assertion that changing the provision of women's APs might save costs. Now, again, with great respect, all credit to my learned friend for making bricks without straw. But to say there's no quantitative analysis in a situation where nothing has been done at all is a fairly bold proposition. Then at 75, at A, they say replacing one or more of the current women's APs with more widely spread facilities, you have the cost and other implications that are above. Well, you already have my submissions on those. They're unevidenced, and there's no consideration of the countervailing benefits. Then they consider the question of closing Bedford and opening one in London. They say, well, that would disadvantage women in the area of Bedford, but they've never examined what the relative levels of advantage or disadvantage would be. One might think intuitively that it's likely that there are more women in need of this facility in the London area than in the Bedford area. Perhaps don't need to take an enormous leap to suspect that might be the case, but we don't know if that's right because they've never investigated it, even though it's up to them to justify this. Then they make the point that Kelly House was underused, and you have my submission on the reasons for that. Then they discuss redesignating a men's AP. They say they make the same point with disadvantaged women outside London. And they say other forms of accommodation already under consideration. So we say that's the entirety of their case on justification, and it fails for the simple reason that there isn't any evidence to consider for them to satisfy the court that there is no less discriminatory or less onerous alternative. Sorry, I beg your pardon, my lord. The final point I want to make about this is that what is disturbing about the analysis that the court finds there is the determination of the Secretary of State to close off any possible consideration of alternatives, of making the situation better. What's being said is, we've never investigated this, we don't have any of the information, but we're determined not to consider alternatives. And we know that's the fact because they haven't considered alternatives in spite of the declaration that was made in 2013, in spite of the criticisms made in 2007, 2008 and 2013 in the various reports that we've looked at. And we say that that's not a sustainable or lawful position for the Secretary of State to take. The Secretary of State has got to take some action. The final issue...
You're out of time.
I realise, my lady, the final issue is relief. And
well, you could come back to that later.
Well, that was the point I was going to ask you. In your judicial review claim, your relief sort is set out at MS page 165 or Appendix 1, page 67, two forms of declaration. The second has an obvious typo, first section 149 when it means 149, and that has to do with the PSED. It's the first one, which is the relevant one. If that's not the form of declaration that you are now seeking, it would be helpful to know.
I appreciate that, my lord, and we'll draft an alternative form over the lunch hour because that's not the form of declaration we're now seeking.
Thank you very much. Mr. Steele? Mr. Chamberlain.
Lady, my lords, I'd like to make submissions with your permission under 6 heads. First, some introductory points. Second, some brief remarks on the applicability of paragraph 26 of Schedule 3 to the Equality Act. As you know, that issue is now common ground, at least the question whether it applies is common ground. But my learned friend obviously seeks to draw a number of things relevant to the direct discrimination claim from that fact, and so I'll have to address that. Third, the question of less favourable treatment. Does the provision made here constitute less favourable treatment so as to give rise to direct discrimination subject to justification? Fourth, indirect discrimination, the question of the PCP. Fifth, justification, which, as you know, arises both in respect of direct and in respect of indirect discrimination. And sixth, relief. So can I start with some introductory factual points? We know that APs were previously mixed gender institutions. We also know that that gave rise to problems identified in the Criminal Justice Joint Inspection Report in 2008, which you have in Appendix 2, MS 492-3. And it's agreed on all sides now that APs ought to be provided separately for each gender. We also know that since 2007, women have accounted for around 5% of all prisoners. That's Mr. Langley's statement at paragraph 3.4 on MS 217. They were, at the time of the proceedings before Mr. Justice Cranston, less likely than male prisoners to be eligible for release on licence and therefore post-release placement in an AP. That's Mr. Langley's statement at paragraph 3.7, MS 218. Now, these facts make it practically inevitable that there will be considerably fewer women's APs than men's APs, and it's agreed on all sides that there could not reasonably be parity in numbers or anything like it. This means that whatever the size, number, and location of women's APs, a woman prisoner will always be more likely than a man to be placed in an AP outside her home area. Women's APs are, on average, smaller than men's APs, and they have lower occupancy rates. The mean capacity of women's APs is just under 19. You have a table of capacities set out in Mr. Langley's statement at paragraph 10.1, MS 233, and that contrasts with a typical establishment capacity of 22 for men, which you have in Mr. Langley's statement at 9.1. I'm afraid the figure of 24, which appears in our case, is a mistake. So it's 19 versus 22 for men. The occupancy rates are set out in Mr. Langley's statement at paragraph 10.2, MS 233. They are 80.7% for women and 94.1% for men. Now, there has been much discussion of the women's AP formerly available in London, Kelly House, near King's Cross. We know that that closed to women in April 2009. The plan at that stage was to redesignate it as an AP for men. That has not yet been done. It was closed in April 2009 because it was underused and unpopular. See Mr. Langley's statement at paragraph 10.4 on MS 234. And he makes the point there that there was, in fact, low demand for women's AP places in London, and it was common for only half of the 18 beds to be occupied. Now, women from the London area are now generally accommodated in either Bedford, which is under an hour from London on the train, or Reading, which is about half an hour away. Now, for some prisoners, a placement outside the home area, as we've seen, is desirable. For the rest, the presumption is that the prisoner will be placed as close to the home area as possible. And for these prisoners, the current configuration of APs will benefit some prisoners and disadvantage others. And I hope it's not stating the obvious to say the same is true of any other possible configuration of APs. Some people will be benefited and some will be disadvantaged. But even those who are disadvantaged will suffer that disadvantage on average for only 80 days, which is the mean period of residence.
Subject to knock-on consequences.
I take that point, yes. And finally, we have the fact that Mr. Justice Cranston found that in considering the proper configuration of women's APs, there had been a breach of the duty to have due regard to the matters specified in Section 149 of the Equality Act 2010. That finding was not appealed and is not an issue here, and it will, of course, have to be remedied once the final outcome of these proceedings is known. But can I just ask your ladyship and your lordships to look at what Lord Justice Elias said about that at paragraph 65 of his judgment on MS 116. Because a great deal has been made by my learned friend in her submissions this morning about the failure of the Secretary of State to act following the decision of Mr. Justice Cranston that there had been a breach of the Section 149 duty. Why not? Why hasn't the Secretary of State remedied that breach at any point since 2013, it was asked? Well, what Lord Justice Elias said was this, paragraph 65, a declaration to that effect, that's to say that there had been a breach of the public sector equality duty, was given below and not challenged by the Secretary of State on appeal. The Secretary of State remains under an obligation to give effect to it. Ms. Rose complains that he has done nothing, although we heard no evidence about that. In any event, I can see why you may have thought it premature to do anything until this appeal has been concluded, in case our judgments impinge on what he has to do. Now, just ask yourselves, my lady, my lords, what an equality impact assessment would have looked like if it had been undertaken immediately after Mr. Justice Cranston's judgment. It would have noted that there had been a breach of the Section 149 duty. It would also have had to have noted that on Mr. Justice Cranston's findings, in fact, the provision of APs for men and women did not give rise to unlawful discrimination, because there was no direct or indirect discrimination, and because in any event, any such discrimination was justified. That is what an EIA would have had to say. It couldn't have said anything different. That was the finding of the court. So when my learned friend says, well, why hasn't anything been done? I very much doubt if my learned friend would have been very happy to see an EIA in those terms. She would not have considered it to be an adequate document. And so it was indeed, in my respectful submission, wholly understandable for the Secretary of State to say, well, in circumstances where you have achieved your declaration under Section 149 before Mr. Justice Cranston, but then chosen to contest his findings on substantive discrimination before the Court of Appeal and then before this court, that it would have been entirely premature to conduct that investigation before these proceedings were finally concluded.
By that logic, what was Mr. Justice Cranston doing making the declaration?
Well, my lord,
you're saying it would be an entirely vain act in the light of his
not a
conclusion.
not
he would be. No, please.
Not at all, my lord, because there are a number of things that have to be considered when one does a Section 149 analysis. So obviously, one of the important matters that has to be considered is whether the arrangements give rise to unlawful discrimination. That's obviously a key factor.
Yes.
There are other factors as well, such as whether the arrangements promote equality of opportunity, which is a separate question.
Well, then why do you say it would be, given that there are other matters which have to be investigated under an EIA, why do you say it was futile to expect one to be done because its result would have been inevitable?
Because one of, and indeed probably the key factor that has to be considered in any EIA is whether the arrangements are in fact unlawful. That's going to be the starting point for any EIA. And of course I accept an EIA goes further than that because the matters set out in Section 149 go beyond simply the question of unlawful discrimination. But one can see why Lord Justice Elias said that one might take the view that an analysis, which my learned friend has said, has got to be a detailed analysis of the position, would be premature before knowing the answer to the question whether the arrangements are substantively discriminatory. If, as Mr. Justice Cranston said, the arrangements are not substantively discriminatory, that's an extremely important starting point for any analysis. And a starting point from which I apprehend my learned friend would differ. So that's the question.
I mean, one can understand that in relation to the position as it's been between then and now.
Yes.
But suppose the appeal were to succeed, we'd still be left with the fact that no such investigation has been carried out for good or ill.
And it would have to be, and it will be. There's no doubt that the Section 149 breach will be remedied once the outcome of these proceedings is known. So that analysis...
a slight element of hope springs eternal about that.
Well, my lords, I take that point up to a point, but with respect, these proceedings have been ongoing since 2013. We didn't choose that. The declaration was made in 2013, and my learned friend and her client chose to pursue the appeal to the Court of Appeal and then to this court.
Have the respondents ever put in writing, we don't propose to conduct this assessment pending the outcome of the appeal because?
Well, you've seen in Mr. Langley's statement, paragraph 9.1, there was another reason given originally for the fact that the analysis had been put on hold. That's prior to Mr. Justice Cranston's finding. They have not put in evidence post Mr. Justice Cranston's finding. Wouldn't be normal for the Secretary of State to file evidence post the finding.
If the appellant obtained an order which the Secretary of State decided she was not going to comply with for the time being, it might have been appropriate to have at least notified the claimant that that was the case and with an explanation, might not?
Well, I take that point, but your Lordship has seen what Lord Justice Elias said about this. It was raised in court below, and Lord Justice Elias accepted, we would respectfully submit correctly, that it would have been futile to perform an EIA in circumstances when the central question which that EIA would have to address was itself in issue before the court. And, my lady, lords, perhaps I can put it this way. If we were to do an EIA now, we would be saying, as we will be saying when I come to my fifth head, this policy is justified. That's what we would be saying. And obviously that is one of the issues which your lordships, your ladyship, will have to determine. Now, the question here, we say, is whether separately from the procedural breach, we do say that the question whether there's a procedural breach is a completely separate question from whether there has been substantive discrimination here. The question is whether the current configuration of APs means that the Secretary of State has committed the statutory tort of discrimination. That tort would be compensable by damages and actionable at the suit of the present appellant, and presumably also any other woman who could show that she had been placed in an AP outside her home area when a man in comparable circumstances would not have been. We say that the answer to that question is no. This is not a case of direct discrimination. Why? Because first, there are male prisoners who are placed in APs far from their home and female prisoners who are placed in APs close to their home. And second, because it is impossible to identify a detriment to which all women and only women are subject. And that test, although it's been attacked by my learned friend, it in fact can be satisfied in each of the cases which she has taken your ladyship and your lordships to. It's satisfied in the Birmingham case, it's satisfied in James and Eastleigh, it's satisfied in the Roma Rights case, and I'll come to explain why in each case. It is not satisfied, we say here. Second, we say the practice of placing women prisoners in APs, though capable in principle of qualifying as a provision, criterion, or practice, is justifiable in the interests of protecting the public and rehabilitating offenders. Other policies or practices that are applicable to women prisoners only do not qualify as PCPs at all. And finally, we say that if and to the extent that the current configuration of women's APs does give rise to direct or indirect discrimination, Mr. Justice Cranston was entitled to find, as he did, see paragraph 60 of his judgment on MS 140, that the defence of objective justification was made out, and the Court of Appeal was right to find his conclusion on that issue sustainable. See paragraph 64 of Lord Justice Elias's judgment. Now, can I start with the applicability of paragraph 26 of Schedule 3, because there are a number of points that we need to make on that. You have it in Authorities Bundle 1, tab 6, MS 1884. Now, can I start by saying that the structure of my learned friend's analysis this morning was to look at this provision, which is in, as you know, Schedule 3, and provides an exception applicable to some cases of direct and indirect discrimination, and say, because of the exception, that tells you what kind of thing must have been understood as constituting direct and or indirect discrimination. Well, we say it doesn't, that is putting the cart before the horse. It does not help to answer that question. It simply provides an exception that applies if and only if it can first be established that what is being complained about constitutes either direct or indirect discrimination. Whether it does constitute direct or indirect discrimination has to be answered by applying the tests which tell you whether something constitutes that form of discrimination. Now, as you can see, paragraph 26 applies to the provision of separate services, that's paragraph 26.1, and to the provision of separate services differently, paragraph 26.2. It also applies, see paragraph 26.3, to a person exercising a public function in relation to the provision of a service as it applies to the provision providing the service. Now, we agree with the appellants that this is a case within paragraph 26.3, but our reasons are slightly different, and that will become important when we start to look at the consequences of Miss Rose's construction, Miss Rose's application of direct discrimination to these facts, because my learned friend put a number of hypothetical scenarios as to what would follow if I'm right on direct discrimination. We obviously will be putting a number of hypothetical scenarios to what will follow if she's correct on direct discrimination. And quite a number of surprising things do follow. Can I start just before we break with this? You can see that there is a distinction, if one turns back to section 29 of the Act, which is on MS 1872, between the provision of services, see section 29, 1 and 2, and the exercise of public functions, 29, 6. So 29 is imposing a prohibition on discrimination in two distinct cases. One, provision of services, subsections 1 and 2, and 2, exercise of public functions, subsection 6.
Well, the public function could be a provision of services, in which case the earlier applies. Subsection 6 only applies to the exercise of a public function which is not the provision of a service.
I agree. And so with that rider, and that rather makes my point, is that there are two separate prohibitions which are being imposed here by the two parts of this provision. Now, the provision of services includes the provision of goods and facilities, see section 31.2, And the distinction between goods, facilities and services on the one hand and public functions which are not the provision of goods, facilities and services on the other has its roots in the statutory history. Now, we've set out in our case the history on these points, but I see the time, but after the short adjournment to come briefly to that history to show how this section works in practice. I think I'd better do that at 2 rather than now.
That clock is marginally fast, but
Right.
if you would prefer us to rise now so that you can collect your thoughts, I'm sure we'd be happy to do so.
Well, let me just show you where in the case it's dealt with. We've set it out at paragraphs 15 to 30 of the case, MS 68 to 72. And just starting that point, one can see immediately that the case law interpreting the old statutes, that's to say the Sex Discrimination Act 1975 and the Race Relations Act 1976, made clear that public bodies could be caught by the prohibition in discrimination in the provision of goods, facilities or services, but only where the acts they did were of the same kind that could be done by a private person. And there are cases such as Armin, which you have referred to there, and Gitura. I'm going to ask you just to look at Gitura, but before we do that, and perhaps one can take it from the case at paragraph 18, one can see that that was a case which concerned an individual detained at an immigration removal centre. So that has obvious similarities to the context of a prison or an AP. And one can see that Lord Justice Buxton interpreted the previous case law as authority for the proposition that acts in pursuit of governmental functions do not fall within the ambit of provision of services. And so it was necessary to look at the various things that were done in an immigration detention centre and separate out those that could be regarded as provision of services from those which could not. So the reception, for example, of detainees would not count as the provision of services. That was something which was a peculiarly governmental function. On the other hand, the provision of bedding and that kind of thing, medical services, would count as the provision of services because it was the kind of thing that a private person could in principle do. And so it was necessary, he found, to look in that way at the precise things that were done in the exercise of public functions to find out whether they fell within the services provision or not. Now, the next stage...
You've now got yourself to 1 o'clock.
I'm glad.
That seems like a suitable dividing line.
It does. Before we delve into the Sex Discrimination Act 1975, I think sustenance is required.
Well, we shall look forward to hearing from you further at 2 o'clock. Court is now adjourned.